We now bring you a Constitutional News Network update.
Ascension Parish School Board, the court held that a defendant school board's adoption of a redistricting plan that concentrated economically disadvantaged students in a majority non-white school district did not violate equal protection as the plan was facially race neutral, and plaintiffs failed to prove the redistricting plan treated similarly situated students of different races differently. Even if plaintiffs had made that threshold showing, they failed to establish that the plan had a discriminatory effect. The Equal Protection Clause of the 14th Amendment mandates that no state shall deny to any person within its jurisdiction the equal protection of the laws. U.S. Constitution Amendment 14(1), its central purpose is to prevent the states from purposefully discriminating between individuals on the basis of race. Shaw v. Reno. Accordingly, laws that explicitly distinguish between individuals on racial grounds fall with the core of that prohibition and are subject to strict scrutiny. Hunt v. Cromartie. Strict scrutiny also applies to government action that is ostensibly neutral, but only if the neutral law has a disproportionately adverse effect that can be traced to a discriminatory purpose. The plaintiffs argued APSB violated the Equal Protection Clause of the 14th Amendment when it adopted a redistricting plan. The plaintiff argued that the record evidence and the trial court's findings of fact clearly show that the race was an important standalone factor in the adoption of APSB's plan, and that a main goal of the plan was to keep a specific balance of racial groups in each school in order to maintain unitary status. Plaintiff's position hinges on the premise that the plan was more than the maps and written descriptions laying out the geographic boundaries of the feeder zones, rather than the demographic analysis underlying this plan classifies students on the basis of race, and this data, as well as the race conscious motives of the board members, events express racial classifications in the plan. Plaintiffs argues that this plan was contrary to parents involved in committee School versus Seattle School District, in which the court held a unitary school district's decision to classify students by race and to rely on the classifications in determining school assignments is subject to strict scrutiny. APSB counters that the district court correctly looked only to the face of the plan to assess its race neutrally, and it contends the court's finding that none of the documents that make up the plan include any reference to race is not clearly erroneous. The board urges this court to follow the circuit court precedent and hold that a school zoning plan that assigns students to schools based on their home addresses is facially race neutral, and the zoning body's consideration of demographic dating and drawing in the relevant geographic boundaries does not amount to making an express classification. Lastly, APSB posits that even if the plan incorporated status analysis, the plan would still not contain any express racial classifications because there is no provision that identifies any classification by an individual student or group for purposes of school assignment, or that require the consideration of race when enrolling students in any school. Similarity in the United States versus Meriwether County. Plaintiff challenged the judgment of the United States District Court for the Northern District of Georgia that approved defendant County Board United of Education 5-year facilities plan. Plaintiffs contended that the district court applied the wrong legal standard in gauging the plan and abused its discretion in approving the plan. The court held, however, that the county school board did not violate the Equal Protection Act in pursuing its proposed facilities plan district, and that it had complied with the constitutional mandate to the extent practicable. In Meriwether, unlike Lewis, the school board did not undergo years and years of studies prior to finalizing its plans. The court held that an important consideration in this context is the school district's good faith. Meriwether County, the court seems to suggest that because the county had previously taken steps to pursue a consolidated school, and that most desegregated alternative and lost that the resulting plan the board decided to pursue was the most practicable and the most beneficial to the most schools in the county. In Lucy, over a period of 4 years, there is a clear record of the school board trying to deal with an essential county school board overcrowding. If a practical and good faith are the standard upon which a determination that race wasn't an important standalone factor can be made, certainly 4 years of research, data, statistics, and analysts that point to many other factors other than race more that achieve the same standard.
I dissent with the majority opinion. I do not share in the opinion that the United States Court of Appeals, Fifth Circuit, upholding the finding of the United States District Court for Middle District of Louisiana that held that the rezoning in Plan Lewis was both facially neutral and that the plaintiff failed to establish that the plan had a discriminatory effect. Indeed, sometimes a clear pattern, unexplainable on grounds other than race, emerges from the effect of the state action even when the governing legislation appears neutral on its face. Village of Arlington Heights v. Metropolitan Housing. The court has a long-standing practice of looking toward the intent of legislation to determine violations of equal protection even when a facially neutral plan or legislation exists. Indeed, when facially neutral legislation is subjected to protection attack, an inquiry into intent is necessary to determine whether the legislation in some sense was designed to accord disparate treatment on the basis of racial considerations. Washington v. Seattle School. In our case, within facts that are undisputed by other parties prior to the school board meeting on January 15, 2008, the school board employed that demographic data to chart 4 alternate rezoning plans which listed the current enrollment and percentage of African American students and free and reduced lunch. Students at each school in the district then projected the enrollment and percentage of African American students and free reduced lunch students at each school under each of the 4 rezoning opinions. Lewis v. Ascension, Par School Board. Since race was used as a factor in the inception of the rezoning options, how then can this court be asked to believe that there were absolutely no racially motivated intent in this subsequent rezoning, simply because of the facially neutral language of the plan? In Eisenberg, in Eisenberg v. Montgomery County Public Schools, a white student was denied transfer to a school after subsequent rezoning and through the use language provided by the county. The sole reason given by Montgomery County for the denial was impact on diversity. In Eisenberg, the court utilized the course language to ascertain discriminatory intent, and in this case, the same references can be made of the demographic charts used in the rezoning plan creation. The board makes the argument that its consideration of racial and socioeconomic demographic data was solely for the purpose of ensuring the district maintained unitary status and does not amount to rezoning plan that classifies students on the basis of race. Lewis v. Ascension Par School Board. However, the issue of disparate impact remains if, as the plaintiffs here are indeed as claimed, that these students in the East Ascension High School feeder zone, opinion 2F, would ensure that the non-white minority students at East Ascension High School would not now and in the future be afforded educational opportunities equal those available to the students at either Dutchtown High School or St. Amant High School. Lewis v. Ascension Par School Board. And analogous to our case with respect to the application and intent of facially neutral plan is Anderson X. Rel. Dowd v. City of Boston. Here, parents of white students were seeking relief in connection to claims that Boston Public School System's now defunct race-conscious assignment system violated their children's rights under the 14th Amendment's Equal Protection Clause, as it has recital effects from the original plan that had race at its core. In this case, since the new school plan used a facially neutral assignment system consisting of a combination of a walk zone for students to choose their school assignment and a random numeric assignment, the court concluded that the plaintiffs have pointed to no evidence that the new plan is applied in discriminatory manner, nor do we see any in the record. This determination was underscored by the fact that the new plan was in response to numerous suits brought against the school system from the old plan, which used race as a factor in school assignments. However, here, the plaintiffs have provided at least some evidence that race was likely a factor in determining the board's rezoning plan. When a governmental policy employs over racial classifications, the impact of race on an individual outcome is clear. As we have explained, courts will then apply strict scrutiny to determine whether the use of the racial classification is narrowly tailored to serve a compelling state interest. See, e.g., Gratz v. Bollinger. Not lost in this review is our recognition that the Supreme Court's emphasis on the idea that when a large percentage of minority students in a neighborhood school results from housing patterns for which school authorities are not responsible, the school board may not be charged with unconstitutional discrimination if a racially neutral assignment method is adopted. Spangler v. Pasadena, City Board of Education. In this case, distinguishably, there is evidence that the rezoning purposefully shifts lines, despite where the people have chosen to live, which may have resulted in downstream effects on both diversity and equality of education by a distinct group of people impacted. Therefore, in light of the school board's adoption of race-based demographic data as the foundation of its rezoning plan, is my assertion that the court has not applied the appropriate level of scrutiny. If strict scrutiny is applied here, the school board would need to demonstrate a narrowly tailored, legitimate government interest for the rezoning plan, and that there is no facially neutral alternative. Since the board has already pointed to overcrowding as its legitimate purpose for the rezoning, the school board should thusly be instructed to show how the plan is narrowly tailored, and that there are no facially neutral alternative to the adopted plan.